July 13th, exactly 7 p.m., and we'll go ahead and begin tonight's planning board meeting. Before we start the agenda, Board Member Sue, can you lead us in the Pledge of Allegiance?
Sure. Will you please stand? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, thank you. And we'll go ahead with the first agenda item, which is roll call.
Okay. Good evening. Board Member Hom.
Here.
Board Member Sue.
Here.
Board Member Wang.
Here.
And President Cisneros.
Here.
Okay, we have a quorum.
Great. Yeah, we have a tight board today, but we will carry on. And so the next agenda item are, actually before that, I always forget this part. This is official city business meetings, and I just want to give like a little preamble before we get deeper into tonight's meeting and share some rules about our meeting conducts. We ask that folks listen respectfully, and some folks may be public speaking for the first time, so things can be stressful. So we want to create an environment that's supportive, and also to not only respect each other, but also respect the board as we are deliberating and coming to consensus with certain city agenda items. So I just want to share that. And there are, if things were elevated, it could lead to consequences, and if there are violations. So just wanted to name that. Okay, and now we'll move on to agenda item 2. Any agenda changes from staff or the board? No?
None tonight.
Great. Any non-agenda public comments? Anyone could speak either in the room or online for up to 3 minutes for anything that's not listed in tonight's meeting agenda. Do we have any speakers?
Doesn't look like we don't have any speakers. Oh, wait, actually, wait 1 second. We have Philip Kake online.
Okay.
Hey, Philip, you're allowed to talk.
Oh, sorry. I wanted to talk on the agenda 5A.
Oh, okay.
Yeah, sorry.
All right. Thank you. So we'll circle back at that agenda item. We'll close that item and move on to consent calendar. We have the draft meeting minutes from June 22nd. If any discussion from fellow board members, and if not,
We don't have the proper members present to be able to vote on that.
Okay, so we'll carry it over.
Yeah.
Great, we'll continue it. Thank you for flagging that. And with that, we'll move on to agenda item 5A, which is to review some proposed zoning ordinance amendments for short-term rental policies. So looks like we'll have a staff presentation.
Yes. I'll just move over here, make it a little more formal. My name is Steve Buckley. I'm the Planning Services Manager, and I'll be presenting on the short-term rental proposal this evening. As you recall, we, let's see, there we go. Yeah, so we're gonna review a little bit of where we've been, and then I'll go over the ordinance that we've drafted at the staff level to address your feedback and the community feedback that we've heard so far, and then we'd like to hear more feedback and make sure that we're on the right track, and if possible, get a recommendation tonight for the City Council. Noting that, of course, there's no rush, so if we end up needing to redraft some things, that's fine too. All of this is basically in response to the housing element and the discussions that were carried on leading up to the 2022 adoption of the housing element, including Policy H19, where this issue was brought forward as something that the city would undertake in the coming years to limit short-term rentals because they do have an effect on the supply of long-term housing for sale and for rent, whether that's a major impact or lesser impact is sort of up to the beholder, but it is one element of how we try to manage our housing supply for all residents. With that, we'll proceed. Last year, in January and in April, we came to you with sort of a proposal for how we would approach this. Then we went ahead and had a workshop and heard back from the community members who are operators of short-term rentals, as well as neighbors of short-term rentals, and kind of their concerns. And I think we've tried to really balance those interests in terms of neighborhood character and economic benefits of having the opportunity to use a property for short-term rental. And so some of what we heard from the board in particular was it didn't really seem to be like a widespread problem or significantly affecting the housing supply, but it was still a worthwhile endeavor to try to come up with some sort of reasonable regulations. One of the key components was to try to make sure that these are owner-occupied, or at least that someone is on site that can manage the activity and make sure it's not a nuisance to the neighbors. But otherwise, seemed like property could be used almost year-round for short-term rental, so long as it, again, wasn't adversely affecting the neighborhood. One of the things that we wanted to note was that ADUs, accessory dwelling units, that are created under state law are, by law, prohibited from being used as short-term rentals. So there's a little bit of distinction that I'll go into later, but basically there's a few things that we can't allow, and that's just not even in our discretion. But generally, it seemed like we wanted to just make sure that people were safe and comfortable on the property, that these were code-compliant units or spaces that wouldn't create a hazard. And also just that we wanted to sort of take a light touch on enforcement. It seemed like that's our general policy. We offer people plenty of opportunities to come into compliance with building codes or zoning codes. We don't go out and look for trouble, but if we hear a complaint or we see something that looks concerning, then we will initiate an investigation, and then that could lead to some sort of enforcement. So that we would continue to take that sort of approach. So in the ordinance, we took an example, looked at lots of other examples, but Santa Monica seemed to have a really good framework. It was very thorough and clear. It spells out what properties are eligible to be used, who's eligible to rent, what the responsibilities are of both the people who are renting the property out and the people who are coming to visit. And then there's, again, some enforcement measures. But to be clear, we talked last time about sort of hosted, non-hosted, semi-hosted, and that seemed to be kind of confusing. So we've adopted the Santa Monica model for this reason as well, because they define terms like short-term rental, less than 30 days. And it's an accessory use. It can't be a primary commercial use of a property. And so in that sense, again, we're trying to maintain the character of the neighborhoods. It needs to be a primary residence of the person who is offering it for rent. So they have to live there at least the majority of the year, either in the space that's being rented out or in a separate space but on the same property. And then they get into home sharing and vacation rental, and so we've adopted those terms as well. Home sharing is where you're actually sharing the same home that you live in. It might be a fourth bedroom, or it might be a sort of connected but separate space, like where I lived when I was a teenager, down in the basement. And so there's sort of those kinds of spaces that are flexible, and they could have different purposes for family or visitors or for rental. But they're not technically a dwelling unit. And then there's vacation rental, which is where it's actually a separate space. It's a separate dwelling unit or a separate cottage or however you want to talk about it. But again, it can't be technically an ADU under state law. So this is often a multi-unit property, like developed in the 40s. There's a cottage in the back and a house in the front, or it's an upstairs, downstairs Victorian, right? And there's a basement unit. It's been there forever. It's not an ADU because it wasn't created as an exception to zoning. It was created under the rules that were in place at the time. And so it's eligible for use as a short-term rental. And then we want to make sure that there's always somebody available, even if the owner and permanent resident is away on vacation, that they have a local contact. So that's some really basic considerations. So again, in the ordinance, we talk about where they're permitted. Any residential building, also boats, floating homes, liveaboards, and then other separate sleeping spaces. But they can't be sort of sheds or, basements that aren't finished. So they need to be places that are habitable and meet code. Not permitted, things like, group housing of different kinds, ADUs. There's also another state prohibition on SB 9 subdivisions, which are these new lot split subdivisions where if you take advantage of state law, again, the intent of that state law is to create permanent housing. So you can't use it for short-term rental. Also, various kinds of affordable housing that's deed restricted, and apartments that have been subject to an eviction of some kind or have ongoing code violations. So that's where you can and can't do it. Again, we want it to be safe, so we have these standards. Has to be up to code for residential occupancy and have various safety features. And then you can't, exceed certain occupancy limits or have commercial rentals, like for parties. You need to have some good neighbor policies, insurance. And then we want to require the operator to actually list their permit number in their advertisements so that we can kind of cross-reference that everyone who's advertising is also registered. That permit number would come through this process that's meant to be fairly straightforward, kind of like any other business license, home occupation, registration process, where it's not a hearing, there's no appeal unless, for instance, an applicant is denied and they are unhappy with that denial. But otherwise, it would be at the staff level, and it would run with the business license, which is renewed every year. So every year there would be a sort of, again, like file your paper on time, pay your fee, and then you're good to go. So we wouldn't have a big review process once it's up and running unless we hear complaints. We would also have a phase-in period, what we're calling an amnesty period. So if this ordinance is adopted, there would be a chance for people to kind of figure out what they need to do. We do some outreach, have the handouts, make sure everybody knows how to get onto our website, and this would all be online, very simple. And then, as I mentioned, the enforcement would be through our standard administrative citation process, which starts with a warning and then, incrementally more serious fines. So that's pretty much it. We're happy to answer any questions tonight and hear your thoughts.
Great. Great presentation. Thank you. I'll bring it to the board for clarifying questions. Board Member Hall?
Yeah, just to clarify. Thank you for the staff report. I did review the ordinance and the notes of the working committee, which I thought did a really good job discussing all the issues. Just one question. It seems like primary residence seems to be a key item in order to allow unhosted. And you mentioned primary residents reside like 6 months or more. I don't see that in the definition, there's a required time period. Is there a reason that wasn't included?
We could add that. It's sort of a term of art. I mean, like for tax purposes and other reasons. I mean, if you reside in California, you must have a regular presence here, and that's sort of the idea. So same with living in this property in Alameda, the expectation would be, even if you go on vacation or whatever, that this is your legal residence.
Okay.
But we could add that specifically.
Okay, yeah, I was just asking because you mentioned it in your presentation, and I noticed it's not included in the definition.
Thank you.
That really was my only question.
Okay, great. Board Member Sue?
Thanks for the presentation, Steve. Yeah, just a follow-up clarifying question to Board Member Hom. So the idea is that if you have well, let me reframe it, I guess, is the only way someone was able to host or have a STR is they have to have a primary residence in Alameda and can only have, technically by definition, and also by the way this is defined in the ordinance, only one primary resident. So the idea is that, what I'm trying to get at is they're only going to be able to host, the idea is that they're only going to be able to host or have one STR because they can only have one primary residence. That's the requirement. That's the idea. Yeah.
Yeah, and I think that's a point of discussion we could delve into. We also specify that it would be on properties up to 4 units. And I think we had some discussion before about, well, what if, say they have a basement unit and a cottage in the back, and they still live upstairs in the main house? Well, could they short-term rental all of the rest of the space? And I think that's still up for discussion. I think we framed it as no more than one of those spaces,
Yes.
and they have to live on site.
Right.
Yeah.
Did this kind of the way that they were trying to approach it here, is this exactly how the Santa Monica ordinance tried to handle this issue, I guess, of somebody having a home that they own in Alameda and then buying another home and deciding, or buying a duplex and saying, let's rent those out? Is this how Santa Monica tried to tackle the problem or that issue?
Right.
Okay.
So there's less speculation.
Right. I mean, just thinking out loud of how to actually enforce that. I mean, you'd have to figure out a way to check if someone, they actually live there and whether it's the time. Okay, I'm just more rambling now. But yeah, I'll have more thoughts on that. Thanks.
Good questions. Did you have any, Board Member Wang?
Yeah, thank you, Steve. I have a couple questions just to understand more the nature of the complaint process, given that it kind of lives somewhere else in the code. So I have a couple examples in mind, if you don't mind, just maybe walking through those examples. So let's say there's an operating STR, they have a permit. Someone makes a noise complaint, and then that occurs a few times within a certain period. Can you maybe walk through what that would look like, what would happen?
Yeah, these sort of temporal complaints are tricky sometimes because we have to send somebody out to verify it. Now, if someone is able to record it with a timestamp and, over time we see a pattern, then that helps us be able to send someone at the right time, whether it's, Friday night, most likely, Saturday night, something like that. We do have a code officer that's, available to go out at odd hours. Yeah, we would try to, take the totality of the evidence, whether it's from the neighbors, then, talk to the owner, see if they can verify or, argue against the complaint. And then we would, as I said, do an investigation.
Okay, but you also talked about, I think it was a 3 or 4 step kind of laddering process where,
Yeah.
let's say you had 4 verified incidents. At that point, you would,
Then we would probably undertake a suspension. So I think what we're talking about is a warning, and then maybe a 30-day suspension, and then, a $500 fine, or, escalating to a $1,000 fine. We would have that system. I'm sorry, I don't know exactly what those steps are, but something
Okay.
along those lines.
okay, I think it's not, I guess in this particular ordinance, it's not super clear. So eventually, when it gets to the, if and when it gets to the administrative piece, I guess having that enforcement process be spelled out, I think would be helpful for the public. I have a second question that's kind of along the lines of Board Member Sue's question, which is to say, let's say you have a permitted STR, and then someone comes and they have a complaint and they say, actually, that is not their primary residence. I wonder if you've considered what that complaint process then looks like, whether it kind of mirrors a more general scenario like a noise scenario, or if it's slightly different.
Yeah. Sorry, going back to the enforcement, there is actually, there's no page numbers here, but on this attachment under 30-19.6F, it talks about the escalating enforcement, warning, suspension, and revocation.
Okay.
Sorry. Something more like an ownership, like a factual investigation is a little easier, and we can verify from their application they're supposed to provide documentation up front, and then we can verify if that's still true, or if there's some other evidence like property ownership,
Yeah.
and those sorts of things.
I guess that what I have in mind, and we can talk about this more in the comment part of our evening, is that if someone is warranted that a property is their primary residence and it's not, you can't really warn them about that. It either is or it isn't, right?
Oh, well,
We're not really going to warn them to move into the STR, I think.
we would warn them that we would revoke their permit, and they would have to turn it into a long-term rental.
Right. So it's a little bit more binary, this situation, than another type of situation, I think.
Yeah, and I think in any event, the warning would be either comply or we will revoke. And so they can do that in any way that they are able.
Right. That's fair.
Yeah.
Okay, switching topics. This was just a clarification question in the staff report. Under the section on types of buildings and spaces in the staff report, you have a sentence that reads, homeowners would be able to host visitors in units that they do not own if they are on the same property. I think that's supposed to say that they do not occupy.
Correct.
Okay. Okay.
Yep.
Thank you. Those are all my questions.
Great. Any other clarifying questions from fellow board members? If not, I just want to double check these items. So this would apply to all ADUs, and you said in your presentation like that all the ADUs are not eligible for STRs, and that's partly because of state law, and therefore newly constructed ADUs are not eligible for STRs, right? Okay, and that's again the logic statement laddering up because state law effectively makes it. Okay, just want to double check on that. And same case with the SB9 units, like it's kind of somewhat already embedded in state law. Sorry, I'm just kind of repeating back just to make sure I fully understand. And then we received a written comment, and my reading of the ordinance, it seemed like the concern with the complaint of this primary house being an STR wouldn't be allowable in the future. This is like the Otis Drive situation. I think the piece that's maybe missing a little bit is this like conversation about the enforcement element, but otherwise it seemed like that would not be allowed. Like it has to, I'm just repeating back again, the host should be in that residence, in that home. Is that right? So
Yeah.
yeah, okay.
Exactly. So,
Okay.
and as was quoted, it's you can only have one primary residence at a time.
Okay.
Yeah.
A host could live in an ADU and rent out the house or whatever, the other unit as an STR, though.
That is a workaround, yeah.
Yeah, okay. Okay, those are all my, oh yes, Board Member Hall.
Actually, you triggered a question in my mind, and I meant to ask this too. When I, excuse me, when I read the ordinance, it also indicates that a host can be a tenant, as long as that tenant is a long-term tenant. So in that scenario, you could have someone who owns the house but does not actually live in it, so they're not the primary tenant. But the tenant is able to rent out their space or the unit as a STR. Is that right? So that's the one exception for a primary residence, that they could actually rent out their rental?
Yes, so it's essentially subletting. With the landlord's permission, most likely. I mean, most leases would say you can't do that without their permission. But subletting or short-term renting of rooms would be allowed for those tenants as well. There's a limit that they can't charge more than their rent cap that's established in the rent program.
Okay, just to bring up perhaps a worst-case scenario, which would be rare, but so you have a property owner that owns 6 homes, say. He rents out all of them to long-term tenants. So all 6 homes can potentially be a short-term rental?
The
If
primary,
If the tenant is. Is the
could,
primary.
yes.
Okay, so that's an exception. So technically, that property owner could actually have multiple short-term rentals as long as their tenants are long-term.
As long as the tenant is the one who's operating the short-term rental. So we wouldn't want to pass through where somehow there's a shadow world of tenants who aren't really tenants, who are then short-term rentaling.
Yeah, no, I understand.
On behalf of an owner, that
Just
wouldn't
want to
fly.
clarify that there is this avenue that's potentially available for a primary property owner to have more than one short-term rental, right?
Right, because the host would not be the owner. The host would be the tenant.
Yeah. Okay, thanks.
Yep.
All right, if no other clarifying questions, I think that's it. Thank you so much
Okay, thank
for
you.
that. And we'll go ahead and transition to public comments. I have 3 written slips here. I'm wondering if we have any public comment speakers online.
It looks like we have 4 online.
Okay. I'm wondering, how does the board feel? Do we want to do the 3 minutes for everyone? So that would be 7. Yeah? Everyone's fine with that?
Yeah.
Sorry?
I'm wondering if there are more speakers.
I don't think we're not going to get more than these, yeah. But we might get more online. That's a point, a good point.
Actually, we just lost one, so we have 3.
We lost one?
Yeah.
Okay, all right. In that case. All right, it sounds like the board, we're all supportive of, because when we tend to have a lot of public comment speakers, we sometimes adjust the comment period from 3 minutes to 2 minutes each, but in this case, we'll go ahead and do the 3 minutes. So I'll start with in-person speaker. We have Warren Wong. Yeah, you want to come up to the podium?
Good evening, planning commissioners and city attorney and planning staff. My name is Warren Wong. I'm a longtime resident of Alameda and also a licensed commercial and residential real estate appraiser, having served for my 30 years after I was a manager of the Bank of America's regional office, as well as 20 years as a probate referee for San Francisco County, appraising most of the estates and trusts there. I'm speaking today in a sense of caution. I'm not saying I'm directly against this, but I just want to make sure we utilize some best practices. And want to make sure that, you know, we take this in consideration. So I just want to make sure we use good safeguards, but let's also understand that when you impose something like an ordinance like this, you're dealing with one of the issues which is called the bundle of rights theory. You know, that's a real estate term and a legal term. So what you're taking away potentially is one's ability to market a property in a broader sense. So please keep that in mind. The other thing I want to make sure you understand is how could this potentially impact something in a property that someone who is a long-term owner that might want to sell the property down the road to ensure the highest value for it in the market if they decide to do like a Prop 19 tax transfer to another residential property as a principal unit for their in another county. Okay. The other thing that well, first of all, I want to say I thank you for writing a good ordinance. I think it had generally good safeguards in language and also some good elements of protection there. I think what the key thing we want to do for the takeaway here is limit, how can I say it, speculative rental, where people buy property just to make it an Airbnb, okay? And having stayed in Airbnbs when I go to conventions around the country, it's kind of a nice thing to have. And as well as it's managed well. But the key thing I want to make sure we're clear about is that I want to ensure that when we do allow these to take place, that we allow quiet enjoyment for people in the neighborhoods. So that's good. So other than that, the only thing I want to say is, oh, okay, sorry.
You left us on a cliffhanger there.
No,
I think we got the sentiment, but yeah, thank you so much. I really appreciate your public comments, yes. Maybe we'll bring it online to the next speaker.
So let's see, first speaker we have is Athena Moghadam. I'm going to allow you to talk.
Yes, hi, good evening. Can you hear us?
Yes.
Perfect. Hi, good evening. This is Athena Andloai speaking. I have previously appeared before you to explain that our family depends on income from our short-term rental to help pay for our property and maintain our housing here in Alameda. We maintain an STR on San Antonio, close to Park Street. And we often host families, people visiting their families in Alameda, and have generally been happy to host people who have been very low maintenance and just a joy to deal with. I did want to ask about the ADU language in the ordinance. The ordinance as written excludes all ADUs. Previously, in some of the feedback to prior versions of the ordinance, as discussed, there was a cutoff of 2017 that was talked about. I've also seen online 2020 cutoffs mentioned for construction of ADUs that acts as a cutoff for when STRs may or may not be permitted. And I wanted to ask why all of that was excluded in the current language.
Yeah, because the state's law does not exclude all ADUs, but looks like in the staff language, all ADUs are excluded. And it was referred that it was excluded because the state law is excluded. So I wonder why Alameda is putting more restrict options on ADU while state doesn't.
And to clarify this, more than likely would impact our family in direct ways. So it's very important to us that this be considered, and we'd be very grateful if you would take a moment to address it.
Okay.
Thank you. I think that's all for us.
Thank you. Thank you for your comments. We'll bring it back to the room. Next speaker is Steve Bussey. Sorry if I said your last name wrong.
Good evening. My name is Steve Bussey. I attended and spoke at both of the workshops we had last year. My wife and I own a home in Alameda that was built in 1885, something like that. In the backyard is a cottage that was built in 1909 as an in-law unit for the owner's mother and father-in-law. We've operated as a short-term rental for the last 12 years. We've had a business license the entire time. Initially, it was just an apartment license because there was no such thing as a short-term rental business license in Alameda, but we've updated that. One of the concerns I have reading the ordinance, it sounds like our use is allowed, given that we have a home with a cottage in the backyard. However, later in the ordinance, it mentions the address has to be the same. And in 1909, the cottage was given a different address. It's 1181 as opposed to 1183 that I live in. And I could see the way the ordinance is written, that a clerk who's trying to approve my application would say, no, you can't. This other property is next door. However, it is on the same parcel on the same property. Just want to make sure that's clarified. Other concern I have is and this doesn't affect me at all, but the fact that there's no grandfather exemption. All they have is 60 days. If someone does not live, if someone's invested millions of dollars in a home and furnished it and decorated it, they've got 60 days before they have to find permanent tenants. That seems like a very short window of time to me. Doesn't affect me, but it just sort of stood out in the ordinance to me. Thank you.
Thank you. Appreciate your public comments. Should we move online to the next speaker?
Let's see. It looks like we have 3 more online speakers, and the next one is Karen Bay. Karen, you are allowed to talk.
Yes.
Oh, Karen,
Whoa.
you have a little bit of an echo.
Okay. I don't know. I think I'm.
Maybe try turning down the volume on the computer.
I wonder if she's connected to two audios. Yeah.
Okay, maybe should we come back to her?
Yeah, we'll come back to you, Karen.
Okay, we'll come back to you, Karen. So then the next speaker is Zadim. I'll allow you to talk.
Good evening, board members and Madam President. I think you've heard from a couple of members of the public today about them being great hosts, and that's awesome to hear. I bring to you a situation that's not so great. As an example, I live on the West End. I have a home across the street from me that was for sale and didn't successfully sell, and so they started renting it on Airbnb at a very affordable price, which resulted in weekend rentals and party after party after party. And the overall effect was very disturbing on the neighborhood and a complete nuisance. The host is not in Alameda. They live in the valley somewhere, maybe in Tracy or Modesto, I can't remember, but far enough where they can't get here with any speed. And so my first issue regarding your language in the proposed ordinance is we're talking about local hosts. I would like to see a flushed out definition of what local means, and not only a 60-minute response time, but maybe a proximity in terms of distance to Alameda, which I think would be helpful in these types of situations. I do appreciate the hosted aspect of your proposed ordinance, and I think that's great. And I'll just end on, I think it's great that short-term rentals are happening in Alameda, and we're trying to regulate them, and that the city will get to collect some TOT as part of this process to offset the services. So that's all. Thank you.
Great, thank you. Next speaker, Julie Ann.
Good evening, everyone. My name is Juliana Cano. I am a 5-star superhost on Airbnb. I'm also a third-generation Alamedan, and I'm proud to call this town my home. So I understand that everyone in this room shares the same goal, making Alameda an affordable and vibrant place to live, but restricting responsible short-term rentals is not the solution to our housing challenges. What short-term rentals do provide is meaningful economic support for local homeowners and our local economy. This additional income for myself and for others help pay property taxes, insurance, and maintenance. It helps me continue here to live in Alameda. Visitors who stay in my STRs are grandparents who visit their children and grandchildren, sons and daughters who visit their mothers, and out-of-town guests who want a safe and quiet neighborhood outside of San Francisco. Our guests contribute to Alameda's economy by shopping local, tasting our local brews, and watching our famous 4th of July parade. However, I also recognize concerns about noise and neighborhood impacts. Those concerns are valid, but they should be addressed through effective enforcement of existing rules, responsible host, already required quiet hours, occupancy limits, and immediate responses to complaints. The small number of bad actors should not determine policy for everyone else. After all, this is not the French Quarter in New Orleans. Alameda has a long tradition of welcoming visitors while preserving the character of its neighborhoods. We are not Oakland, we are not Berkeley, we are not Santa Monica, or other cities who have long-term rentals. We are a town with very limited and clean and safe accommodations for our grandparents who are visiting their grandchildren. Our short-term rentals offer clean and safe accommodations. Having long-term rentals will not only affect us rental hosts, but will affect the grandmother who is visiting their grandchildren for the week and their families. I respectfully ask the council to continue support well-regulated short-term rentals. They strengthen our local economy, help residents remain in their homes, and provide safe and clean accommodations for visitors and families. Let's focus our efforts on addressing the true causes of our housing shortage while preserving an important source of income for Alameda residents and an important asset for our community. Thank you for your time and consideration.
Great, thank you. And I guess the next online speaker.
Okay, and the next person we have online is Philip Kage. So Philip, I'm going to allow you to talk.
Can you hear me?
Yes.
Okay, thank you. Thank you for the well-considered ordinance. I am a real estate agent. I've been a real estate agent in Alameda for over 20 years, and I also operate short-term rental. It doesn't really affect me because the ordinance, because I live in the unit, it's a duplex. It's all up to code. It's not an ADU or anything else. I'm not hosting a private home. However, from listening to this, I think if what I'm concerned about is, say, single-family homes that are excluded because the owner doesn't live there. A lot of times, just from the market standpoint of how an Airbnb or a VRBO operates, having a larger home is it's a nice amenity to have for a larger family who's traveling. I don't really see where the speculators would come into Alameda and start to buy up homes. I don't think that there's a market to be had for somebody to really make a large amount of money off of something like this. I don't really see that as something that would it just wouldn't attract the kind of person who would want to get a return on an investment like that. I do, unfortunately, hearing about the gentleman's home in the West End where there's parties. I think for the most part, the people that I've had through have been very quiet. There's a very low impact on the neighborhood, and in fact, probably in some cases less, because there's not another car here permanently. So I think I'm certainly all in favor of having good rental policies and a good ordinance, but I think there is an aspect to this where you will eliminate certain people that they may own a home, they may not live in Alameda. Unfortunately, the other situation on the West End is kind of an extreme example, but a large home as a rental is a valuable property. So just by excluding them, you'll be cutting out a certain part of the market for the people that do want to continue this as an economic activity. And other than that, thank you for the time.
Thank you. We have more speakers.
Yeah, okay, so we have, next up is Catherine Chang. Catherine, allowing you to talk.
Hi, can you hear me?
Yes.
Okay. Hi, so my family owns a unit and I actually live next door and I manage the unit. And we've had situations where there was some nuisance and the neighbors have my phone number and they call me. I call the cops or had to call the fire department. And it's been very smooth. But this is I'm a single mom, and it's a second income to me. So creating all this ordinance could create situation for myself, even though my family owns it, and I help them manage it. And the people that do come here and that stay at our place are usually people that work in Alameda, or they come to visit. We get a lot of traveling nurses. And so there's just a variety of people, and we have our set rules. So I know that some Airbnbs don't have strict rules like we do, and I live right next door, so I'm able to accommodate any issue that goes on. What else? Also, question is that we rent out rooms. Some are long-term rentals and some are short-term rentals. So would that make a difference if they're not all short-term rentals? If there's some long-term rentals, some short-term rentals? I think that's mostly it.
Thank you.
Okay, and then that's it.
That's it? Okay, great. And with that, we'll go ahead and close public comment and bring it back to the board for deliberations. This is to help inform a recommendation to the city council where that decision will be made. So, you want to kick us off? Yes, board member Hahn.
Maybe just to start, does staff want to respond to some of the public comments, the questions that were asked?
Yeah, sure. Obviously, the bundle of rights and quiet enjoyment are fundamental real estate considerations. I don't think short-term rental is necessarily, I don't know. I'll leave it to the city attorney to say whether that's a protected right or just one of many rights that we're regulating under our police power. But as far as the ADU cutoff, I do see where the staff report didn't distinguish exactly that we were going beyond state law. So these laws were enacted in 2017, and so they do essentially take effect then. And so anything before 2017 could be considered grandfathered or, exempt from that state prohibition. We went ahead and just made it all ADUs that were developed under ADU law, again, meaning they received exemptions from standard zoning, either for density or setbacks or some other development standard. Because we don't really have that many that are pre-2017. And so what we would do is basically just screen all the applicants and just figure out, does it have an ADU tag on the permit? And if it does, then it's eligible unless, again, it's either renter occupied and that's being sublet, or owner occupied and the main building is being used as the STR. So there would be a couple of exceptions built in there, but it's termed as if it can't be used as a short-term rental as an economic activity solely as the primary activity. So would we also exclude renters from STRs? Maybe we would.
So I actually wanted to make a comment on the ADU issue.
Yeah, please do.
If I could. So as Steve mentioned, the ADU state law has prohibitions against short-term rentals for certain classifications of ADUs and junior accessory dwelling units. That the state law has changed over the years, and it's very difficult to track exactly which categories of ADUs have those particular rental restrictions. It's generally, you can generally base it on the year that the ADU was constructed, but there are so many different exceptions to that and fact-specific cases because, as you know, our ADUs sometimes they're built in 1909 and they were not legally permitted until 2018. So is that an ADU that is created under state law, or is it a grandparented ADU? It's really a difficult type of decision to make. Also, the city's code for quite some time has also restricted ADUs from being rented on a short-term basis. And so given the complexity with this, staff is recommending, and of course it's up to you all, but staff is recommending that it is very difficult to figure out which ADUs are required to be restricted for short-term rentals under state law and even under the city's own ordinances. And so we're recommending a blanket prohibition against short-term rentals of ADUs for that reason, because it is too difficult to differentiate from an administrative standpoint, the various categories. So just wanted to give you our full reasoning there.
I put picture up on the screen, if you would indulge me just for a minute. So this shows a typical Alameda neighborhood. It's got sort of mixed historical zoning and development patterns, but it's very mixed. If you go to the next one, this is off of Park Avenue and Broadway. This is where today some short-term rentals are available, and they're going rates for a 2-night stay. This isn't all of them by any means. As you zoom in and out, different ones appear on the map, but this is kind of a smattering of today's rentals. And there are all kinds of rentals. I looked some of them up, and they're all kinds of properties. And I wanted to just show you some samples, not of these literal ones, but similar ones. Go ahead. So on the left here, you have a 4-unit, building. It has a front door, but really the other entrances are on the side, and there's parking in back. In the middle, you have a front house and a back house. And one or both of those could also have 2 units in it. And then another 4-unit project next door, or probably more than 4. And so all of these may or may not be eligible depending on if the owner lives there, or if the tenant has the owner's permission to then sublet essentially a room in their apartment or rent it out while they're gone on vacation, things like that. Another multi-unit building, kind of the same deal. I lived in one of these for a while, and the owner lived upstairs in the owner's unit. It was a bigger 3-bedroom unit. And then the other 3 tenants had 1-bedroom units, and we all got along great, but the owner was always there. And so theoretically, they could short-term rental 1 or more of those units, depending on how we write the ordinance. Next. And then, houses with the basement unit or a duplex side-by-side, upstairs, downstairs. There's all kinds of traditional housing forms. These are not ADUs necessarily, but they're, duplex and other kinds of units. And so we're not saying that those can't be short-term rented as long as the owner lives on site or the tenant has the owner's permission. One more, I think. And then the courtyard units. That's a really tricky situation. But again, I think you get the gist of it. We just have all these housing types. So we're not prejudging any of them. We're just trying to say that for most people who probably move into these multi-unit buildings, they're not expecting to have a hotel room next door. They're hoping to have a community, people that they know, that they can talk to if there's a problem, that there's some stability in the neighborhood. And I think that's really part of what we're getting at, is also these multi-unit properties have other people living there. And so we're trying to also recognize the rights of those tenants and neighbors. And I'll just leave it there.
Yeah, go ahead.
Yeah, no, thank you for that explanation, Steve. I guess clarification, I'm looking at the ordinance, and this is 30-19-4, B3. And it says, I remember reading this, a host may rent no more than 1 dwelling unit or other habitable space as an STR on the same property at the same time. So does that mean that, say, an owner owns a duplex, they have a tenant living upstairs, and they live downstairs, or vice versa? Does that mean that at any one time there can only be 1 STR rather than 2?
That's how we wrote it.
Okay.
And so we're being very strict on that.
Okay. I just wanted to make sure I understood that was what the intent was. Yeah. Okay.
Yes, Board Member Sue.
I just have, this is more of a question also. So appreciate the explanation on the ADU law and understand that it can get very complex as they add more housing laws. It just gets more and more complex. And so I understand the approach of just, saying they're prohibited. But I think it would be helpful to just include some language as just a guidepost for the public, because I understand, internally, staff probably has their notes and they know like, oh yeah, it says this, but we flag it and blah, blah, blah. We do our own due diligence to figure out. But I think for somebody buying a new property, right, they see this and they go, oh, that won't work for us. But actually, in reality, it might work, but it's very complicated. So, and I know it's complicated. It'd be hard to write something in here that would just make it a little more clear. And I even, your example of the cottage built in 1908, and then maybe in 2005 they started using it as a B&B. I don't know when B&B came along, but just say 2005 or whatever. But then they didn't get legalized as an ADU in 2019, but they've been doing it for like 10, 15 plus years. Are we now going to say you can't do this anymore? I don't know what the state law says, but I think like in that example, they should be allowed to continue doing it because they've been doing it for so long, despite their legalization later on. Yeah, anyways, I think kind of my bigger comment / question is I think it would be helpful to include some language in here just as a guidepost for the public that it's not some blanket ban. I mean, unless staff is like, look, there's only like 5 properties. Like we've done the analysis, and there's only like 5 properties in the city that fall under this, and so that's why we're doing it. Then I'd be fine. But I would imagine just see by you showing me all these different examples that there's probably ADUs in the city that we just don't even know about, that someone's lived in there forever, and maybe at some point they want to Airbnb out, and they would be confronted with this ordinance and be like, oh, I can't, but maybe they actually could.
Yeah, I'm thinking back, the former director, Andrew Thomas, was telling me a little bit about the history of ADUs in Alameda as well. I think he said that really there was an amnesty period already where people with these basement units or cottages that the permitting history was a little uncertain. Maybe there was a record on file, maybe there wasn't. They were actually given an opportunity, probably 15 years ago, where the city really took the initiative and tried to bring people in and kind of just deal with it. So I think if someone were to come in now and try to legalize an ADU, I think we would do that other research first and try to show that, no, actually it was built according to the code at the time. And, we only had zoning since 1940, roughly. So, prior to that, there was lots of development that happened, and we have Sanborn maps and other ways of documenting legal development that's okay. And we wouldn't try to legalize it under an ADU law necessarily. So it wouldn't get knocked out just because of that. So I think it's it will affect probably a couple of hundred units citywide, not short-term rental units. I mean, probably, like you said, 5 short-term rental units that are technically ADUs, maybe 10. I don't know, but it doesn't seem like it's really that many.
Okay, thanks.
I think it's probably more likely going to affect the single-family home where people own 2 homes in town or don't live in town at all.
Yeah.
Great. Any other comments or feedback? Yeah, Board Member Wang.
I have a lot of comments. But first, I would just echo Board Member Sue's comment. I tend to agree that if there was some kind of secondary structure that predates ADU law, but it later became more formally permitted, I would think that should just kind of slide under and be allowed. I do think that, we have a policy objective with ADUs, and that is to say, given our longstanding housing supply issues, that ADUs have been a way that we've been very intentional about creating a new form of density in our existing neighborhoods. And we've also added on, policy incentives such as waiving impact fees for ADUs, right? And that is all in service of creating more long-term housing supply. That's not to say that ADUs are guaranteed to become long-term housing, but I think that explicitly allowing them to be short-term rental housing is certainly not in service of creating long-term housing supply. Bigger picture comment, I think a lot of the discussion on the workshop nights and tonight has focused on noise and nuisance questions, which I think are totally valid. One of the comments that I made earlier on was I'm not sure that short-term rentals as a category of product naturally have more land use problems than otherwise. But I think I'm happy to be proven wrong. I think a couple people have spoken up to say, well, look, if the owner or the host isn't here, like we tend to see some nuisance issues crop up. But all that said, to me, I think noise and nuisance are still not the primary issue here. Just going back to long-term housing supply, we do have that as a primary policy objective, and that is codified in the housing element that the city adopted, as Steve has pointed out already. And so we are here to pick that thread up following the adoption of the housing element. We are, I think, I'm not sure if you said this, Steve, but you said it earlier in our prior workshops, we're probably among the last of the cities in at least the East Bay or in the vicinity to be adopting this. And over the years since Airbnb has really become popular here and across the globe, I think we've seen a lot of ordinances regulating short-term rentals, and so they, I think the market's kind of used to seeing them now. It should be. It shouldn't be a surprise. And two, I think if anything, we're kind of aligning with the market at this point. So I generally, I think where we were going with our workshops was good. I'm pretty pleased with how it's turned out. I did think the structure of hosted, semi-hosted, and unhosted was helpful for us to start thinking about the kinds of short-term rentals that we wanted to regulate or allow or disallow. But ultimately, I agree, the nomenclature was starting to throw us off. I do think the new structure is a lot more easy to understand. So I'm glad that we found that precedent and we're following in its footsteps. I think I have a couple more comments. I guess as a parent in a family that travels, I am sympathetic to the notion that larger homes are helpful. But again, I think I don't think we're going to be under any illusion that passing a short-term rental ordinance is going to boost our housing supply significantly, right? We're not looking for a silver bullet, but in many of the conversations that we have here, we are looking for important but incremental steps to support and shore up our long-term housing supply. So I think here we're looking to make a balance between supporting long-term affordability for people in the Bay Area and also allowing kind of a reasonable flexibility with people's properties, recognizing that being able to rent out your home or your second unit on your property supports long-term affordability for homeowners. So I have some kind of micromanagement type of comments that I think relate to relates to, I think, this concern about primary residence. And so understanding that I think we're largely kind of focused on the honor system backed up by, I think, complaints or enforcement. I do want to I think one reinforced that, it's not so much about showing documents that have your address on them, right? The primary point is that is your primary residence. So I think that there's, we want something that maybe is like an affidavit where you actually say that, and then the documents are supporting. It's not that the documents are primary, if that makes sense. The second thing is, and I kind of alluded to this in my question, is I don't know whether multiple warnings make sense in the context of somebody misleading about whether a short-term rental is their primary residence. So I do think that, if somebody did that and it was found to be untrue, then I think we should recognize as a city that application was made in bad faith. And so it should really be a one-tier warning. I don't think that they should get multiple chances at that. The second thing is, I think that you noted, or the proposal was that if an applicant loses eligibility for their short-term rental for whatever reason, that they aren't able to reapply for 180 days. Is that right? So I think at least in the context of a sort of false primary residence scenario, that it shouldn't just be the applicant that's not eligible to reapply for 80 days, but in addition, the property in question should also be barred from being a short-term rental for 180 days, regardless of who applies. I think those are all my comments.
Thank you. Board Member Hahn?
Yeah, just taking time to now express my thoughts on this. First of all, I think this is a well-crafted ordinance. It's a nice balance between recognizing that we need some enforcement authority for the bad players that happen, and unfortunately that does happen, but also recognizing that, quite honestly, the vast majority of short-term rentals are not a problem. So it's not, you don't want to over-regulate and have staff spend a lot of time, but at the same time you want the teeth to be able to enforce if you need to. I think it is a good balance, like I said, so I'm ready to support the ordinance. I do have some suggestions to take into consideration, some of them supporting what other board members say. Even though it's complicated, it does seem to me that if an ADU was grandfathered in as not truly an ADU pre-2017 or 2020, it is basically grandfathered. I know that creates complications from an administration standpoint, but it seems that they're technically not an ADU under the state law, so maybe they should be exempt. I do agree with Board Member Wang about the violation. I mean, to me, the multiple warnings come in for operational issues, noise, they're having a big party, or other operational violations of the standards. Those are subject to warnings. But if it turns out the person no longer lives there, it could be they may represent it correctly, but then they moved out or whatever, then it should automatically be terminated as the ability to operate an ADU. One comment, just responding to a comment from the audience, and I don't know where this is, I was looking for it. There was a comment that, if there's, say, not an ADU, but a living space that might have a different address on the same property as not an ADU, maybe clarifying if it's a different address that doesn't apply to the exception. And I don't know where that is and whether that's actually correct or not, but if you could check on that. The other comment, and this has to do with the definitions in the ordinance. I do agree, and I'll throw it out here for consideration, There was a comment about the local contact, meaning the person that needs to be responded within 60 minutes. It does seem to me that it's fair to require that that local contact reside in Alameda. So that's kind of one of my suggestions. I don't think that would be too prohibitive. Otherwise, you could have someone living up in Lake Tahoe and say, I could respond within 60 minutes or whatever. So that's one suggestion. The other suggestion is the definition of primary residence. I'm open to the idea of placing some type of time limit, like, you need to, be permanent resident, meaning you're living there, at least 6 months out of the year. And also, since we are allowing tenants to host STRs, maybe it requires also providing evidence of a long-term lease on the property too. That way it's not just someone rents it for 3 months or whatever. And then a final amendment suggests, and this is kind of what brought up under that item 3, it might be good to clarify the issue about only one STR rental on, say, a multi-unit building, because when I read that, it says a host, where that could be interpreted as on the property you have a property owner and you have a tenant. So that means both of them can serve as a host. But it might be good to clarify that so there's not any confusion down the road. So otherwise, I think staff did an excellent job with crafting the ordinance, listening to all the various feedback from board members and the public, and coming up with a ordinance that, to me, is clear, but not overly complicated. So using Santa Monica as an example sounds like it was the right way to go.
Thank you. And I'll just add, we actually are more liberal than Santa Monica. They prohibit the vacation rentals. They define it and then prohibit it.
Oh,
and
okay.
So we're
Okay.
At least allowing it.
Yeah. That's one clarification from the comments, is that we are allowing both, I'll use the term, hosted and unhosted. The only requirement is that it needs to be the primary residence. So for the person that mentioned they have a large home that they would like to rent out, that's perfectly fine. You could be away from that residence. You just have to be the primary resident of that house.
Board Member Sue?
I just had a follow-up question on the ADU prohibition. You mentioned that in the city already bans the use of ADUs for STRs. So that's like in another section of the city's code. So then, for existing, I guess that it's possible that there are some existing ADUs that are being used as STRs technically in violation of the city's code at this time, or has it just been basically unregulated?
Yeah, I think if we got a complaint, we would investigate it, and it would be violating sort of the ADU section of the code, since we don't currently have an STR code.
Okay.
I'll also point out that when you all updated your ADU ordinance, you did make an amendment to specify, to continue forward that language prohibiting ADUs from being rented less than 30 days. But then there was also a provision inserted that said, unless otherwise authorized by this code. And the reason for that was we weren't sure how you were going to come down on this issue. Right. So you do have some flexibility.
Okay. Yeah, and you read my mind on that, because
okay.
my next point was, if we were going to put something in this ordinance to say, unless otherwise prohibited, right, ADUs are prohibited, would we need to then go and modify that one? Sounds like okay. So I still think I would support, kind of just bringing back to our conversation of the ADU ban, I would still support some language in here just to give the public a signpost. And I understand it doesn't end up being too many ADUs, but I think just to to the kind of overall comments about, if you're a potential buyer of this property or potentially thinking about moving here, just being able to know that, and you're looking at this section of the code, just seeing that signpost, I think, would be really helpful, and not for people thinking that it's just a complete ban. So just a couple other comments. I wanted to just circle back on Board Member Wang's comment about the primary residence requirement. I think he's really on point with that, and we may want to just, I think the way when you look at the way the definition is drafted right now, it might, someone I could see arguing, saying, well, I've provided, I've got 2 registrations here, 2 registrations here, I've got my primary, even though at the end it says a person can only have 1 primary residence. So I would try to redraft this to say something along the lines of, like, basically what it says, the usual place of their housing, which shall be as shown by something where we're not emphasizing the registration as much, but more as the registration as supporting material. So I also just had this thought of, I think this is Board Member Ham's comment of, there are some people, and I think this is maybe not as common here, but where you have snowbirds where they spend 6 months here and then 6 months somewhere else throughout the year. We might end up having those situations where they will still, it's almost like they have primary residences in 2 places if they're 50-50, and I guess under this code, if they, I think that will end up having to be, if we go like this kind of affidavit route, we're just going to have to make a call at the end of the day of what we're kind of comfortable with. But I think in like those kind of scenarios, it would not be the same as someone, buying, like living here in Alameda and then buying a house and then registering their voter registration and their, utility bill there and saying, well, I also live there. So, I think that's the kind of issue that we are trying to address. And just to Board Members' comment about the local host, I had the same thought of, like, why don't we just make it so that someone lives in Alameda? And I tend to agree with that, but I also feel like maybe it might be too restrictive. Like, what if that person just lives in, like, Oakland and San Leandro? Like, maybe the language is sufficient enough to say, look, they can respond, even though, respond is so vague, but maybe that goes to the point of maybe we don't want to overregulate. So I'm a bit on the fence on that language. But I also, I don't want someone to abuse it and be like, oh, well, you live in Sacramento and that's enough. They can respond by text in 60 minutes. So maybe we do want to try and tighten that up a little bit. But overall, agree. I think that I think the Santa Monica model is a good model, and I appreciate staff's work on this and all the kind of input they've provided.
Thank you.
Any other comments or feedback from board members? All right. Well, with that, I'll just share that I'm in agreement with my fellow board members. I think this was really thoughtfully put together by staff. I feel like this is a really challenging issue. I mean, I'm very sympathetic to members of the public that use short-term rentals income as part of their livelihoods, and this is going to be a big adjustment. And I also think it's a fair point that I don't think, we're not Santa Monica, we're not San Francisco. This isn't going to change the speculative market trajectory. And I do think this is responsive to what we have articulated in the housing element. And I do think this is a reflection of our values of how we want to have available homes for people to live as their true home, like long-term housing. So for those reasons, I'm supportive of this draft, and I think a lot of the recommended amendments make a lot of sense. So support all my fellow board members with that. And I think a lot of this comes down to like intent. So I don't know if we want to solve for that now and do a little bit more deliberation, or if like staff feels that they have like good direction from the board. Like I'm curious if we could bring it back to you all if you have any follow-up questions for us.
Yeah, I do. I wanted to ask you all in terms of this question around sort of legacy operators who are already up and running, don't have any complaints, depend on the income. You know, we had an amnesty period. It could be extended or it could be more indefinite, like if you can show that you've been listing your property and we look and we've never had any complaints, maybe those people are okay. And we're really just trying to regulate those future conversions, which we do under the eviction clause as well. We're trying to keep people in their homes, and so, you know, there are those protections already, and we're recognizing those. But as you were saying, like, are we trying to now open up more of these units as rentals, or are we trying to solve a nuisance problem? Because if they're not a problem, then maybe the legacy operators could continue. And I just wanted to run that by you because I heard a little bit of concern among the people who are here.
I'm not sure I'm following. Are you? Because my thing is it that obviously there are existing ADUs that are operating as short-term rentals, and obviously you're saying those have been fine. So,
well, actually, I'm not talking about ADUs because those are already regulated, but more like the person who owns two homes and
I see.
Lives in one and rents the other as a short-term rental. Are we trying to tell that person they can no longer do that, and if they come in for a permit, they're going to get in trouble, or if we find out about them, we'll have to pursue them for enforcement? Or are they okay if they come in for a permit? We can say, great, you know, if you can show that you've been doing it for X, you know, time period, like you've already been doing it for 6 months or a year or 2 years, and we haven't gotten any complaints, maybe there's a solution to that.
I mean, I did just have kind of a similar thought. I mean, because we received some comments of folks who have been doing this for a while, and I would generally be supportive of that idea. And I think there's that question of like how long, kind of this cutoff point. But the other thing, I wonder if this like, could somebody make an argument of like, I'm being treated disparately because I'm trying to do this after the ordinance was put in place. I own a second home and I want to do this, but just because of past this date, it's no longer allowed. I mean, I think this is a good idea, but I just wonder if someone could make that argument to get that kind of permission struck down.
Yeah, I mean, I think that's always the case when you pass a new rule.
Yeah.
So.
Isn't kind of a key item, state law prohibits STRs for ADUs. So part of to me, a key guiding point is this an ADU under state law? Mm-hmm. However you define that, I'm not saying that's a clear definition, but state law specifically prohibits short-term rentals for quote-unquote ADUs. So as long as it's, if it's outside of that state definition, then I'm open to allowing the short-term rentals.
For the legacy versions or going forward? Because that's the real cutoff here, is it has to be your primary residence.
Yeah, it's just the question is, or any of those legacy ADUs covered under the state law prohibition?
I think ADUs isn't, I think it's like a legacy unit, right? Because
or
ADUs
short-term
are not,
rental. Short-term rental.
Yeah, legacy short-term rental that are not ADUs.
Yes, correct.
Yeah.
Okay, yeah. Okay. Because if they're not ADUs, then there's not a state law issue, right? It's only if they are classified as ADUs. Am I missing something?
It's not I think what Steve is asking is if there's an owner and they're operating, let's say, a single-family home that's next door as their ADU. Under the ordinance as it's written, they would no longer be allowed to do so, right? I think Steve is saying, do we want to provide some kind of amnesty program for people who have been good actors? Am I?
Well said.
Yeah, I mean, I'm open to that as long as it doesn't violate state law.
Yeah, and I think, yeah, I agree with the consensus that we're coming to, and I think the question for me is how long have they been proving to be a good standing STR business owner, I guess? Like, I don't know, like it seems like 1 year maybe is not enough evidence, so I think that's my question. I think you were getting at that, Board Member Sue, so I don't know if it's like, I don't know, 2 years, 3 years. But yeah.
I would support a year. I think that.
Oh, yeah?
Yeah,
Okay,
I think that would
fine.
be reasonable. Yeah.
Me too.
Okay,
Yeah.
fine. I will support that.
That makes sense to me, where someone has come to depend on it, and
I would say, though, that if that permit, let's say this grandfathered permit gets revoked, I would say they don't get to come back and redo it.
yeah.
Great.
That sounds fine to me.
Yeah. All right, great. Any other clarifications or things that would be helpful as you're putting together this recommendation, Mr. Buckley?
Where did you land on the response radius?
Whether living in Alameda or not? Yeah, that was a good question.
Yeah.
Because
I don't think we solved that. Maybe it could, I mean, we say 60 minutes.
Yeah.
Okay, I just throw this out there because I don't have a problem with Alameda, but I can understand maybe some more flexibility. I mean, they need to be able to respond maybe on site as well as by phone within 60 minutes. Might that be? Because within an hour, you could live in Oakland or San Leandro, but there might be a case where you want them to be able to, be on the premises. Yeah. So I throw that out as a suggestion because I agree Alameda might be a little bit too restrictive.
I would support that recommendation.
Okay, so is it live in Alameda or be able to respond on site within 60 minutes?
I think it's be able to respond within 60 minutes, including arrive in person, right?
Yeah.
Have the ability to arrive in person within 60
And I
minutes.
assume if they live in Alameda, they can respond in 60 minutes, right? Of course, unless there's like massive traffic congestion.
Or they're working.
But I won't go there.
I know. Yeah. Does that work for you too, Board Member Wang?
Sure.
Okay.
Thank you. I think we got it.
Okay, great. Any other, yes, Board Member Hom.
Oh, no, I don't. I was just going to make a motion.
Okay. Yes, go ahead and make a motion.
Yeah, well, let me pull up the staff report to make sure what you're asking us to do. Yeah, so I make a recommendation that we recommend to the City Council to adopt short-term rental regulations and ordinance as recommended by staff with the revisions discussed tonight by board members, and further finding that the ordinance is exempt from CEQA.
I will second.
Okay. All those in favor, say aye.
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 No opposition. We have 2 absences, and the motion
The
carries.
motion carries.
Great.
Yes, thank you.
Thank you so much to members of the public, both here in person and online, for all your contributions. And with that, we'll move on to agenda item 5B, which is a workshop on commercial zoning.
Right.
Hello.
The button on the right.
Ah, there we go. Okay. So we are here to provide an overview of the downtown commercial zoning code update for Park Street and Webster Street, which are Alameda's two main street corridors. Our project goals are to reduce storefront vacancies, reduce regulations that create unnecessary burden for new businesses, modernize, clarify, and simplify the zoning code, build flexibility in the code to allow for emerging business types, all while maintaining the active pedestrian-oriented district that it was originally envisioned for. To understand the potential impact of these changes, we analyzed the commercial building stocks in both areas. Observations include that Park Street contains around 1 million square feet of commercial space, roughly twice the amount of square footage of other East Bay business improvement districts. Retail and restaurant uses make up nearly 50% of commercial square footage within each district. And if we include office and mixed-use buildings or square footage, that percentage ramps up to around 85. And over half of all commercial buildings are 4,000 square feet or smaller. Looking at the vacancy specifically, we see that commercial vacancies rates are sitting at approximately 12% on Webster Street and 7% on Park Street. Staff categorized these vacant spaces into 4 groups. The first 2 represent the most common vacancies and are expected to benefit from the proposed zoning updates. The remaining 2 would likely require more targeted interventions beyond zoning changes. And as for our process, staff held 3 workshops with representatives from the Webster Street and Park Street Business Association, planning board members, and other key stakeholders to help shape the recommendations. Following the study, staff will return to the planning board in September and then the city council in fall for adoption. And with that, I'll pass it over to Henry for the recommendations.
Thank you, Caesar. It's Caesar with the Economic Development Department.
I was just going to ask. Yeah, thank you.
Giving a little overview of what we've gone through so far in our effort and some of our goals. And so I'm going to go ahead and, Henry Dong with the Planning, Building, and Transportation Department. And I'm going to go over some topics that we would hope to hear back from the board and the community on. So first off, I'd like to express my appreciation for the working group that we had with the DABA and WABA stakeholders, and then Board Member Wang and Member Ruiz. A lot of the insight that they gave us in those meetings will help to shape our how we approach this project. And so I guess the question here is, how do we streamline the code and the process to help to reduce some of the vacancies that Caesar was talking about? And so staff is recommending mainly 3 approaches. First is to consolidate the list of permitted uses where possible and move the code format to a more modern format, similar to the Alameda Point District and the North Park Street District, where they use more general terms. And then number 2, consider removal of requirements for use permits for certain uses where it's possible. We really want to reserve the use permit process for those types of uses that we want to review on a case-by-case basis, or uses that we want to implement conditions of approval to. Because I guess the use permit process includes a public hearing, and that usually can add about roughly 3 to 12 months worth of processing time to a project, which will also create uncertainty for prospective tenants that may be choosing between a location in Alameda or a location in another city. So these are some of the aspects to consider. And so we think it's worth taking a second look at some of these uses that we're going to be talking about. The other thing to consider is accessibility, because we have some uses that have limitations from being located on the ground floor or actually prohibited from being on the ground floor. But in Webster Street and Park Street, we have a lot of older buildings that may not have elevators, and so accessibility is another thing that we're thinking about. And then lastly, we want to take a look at clarifying and modernizing the code. So the first item to talk about here is list uses, not shops, right? We want to consolidate the dozens of retail, shops, and personal services type uses all into like two main definitions, which is general personal services and general retail sales. By listing individually, it really creates kind of a unclarity for those uses that aren't specifically listed in the code, and it also requires that staff make similar determinations if we're going to allow those types of uses. And so it makes sense to group them into general terms to make things more flexible and clear. So when we're talking about retail use, just about most of the retail uses are allowed by right on Park and Webster Street. There are a few uses that we would like to take a second look at, and one of those is retail used goods, which actually require a use permit in the CC district. State law states that cities must treat these thrift store uses the same as new retail uses, retail store uses, and so we're proposing to eliminate the distinction between new and used good sales. And so I guess this one's more kind of like a FYI, but we'd like to hear your thoughts on that. The next retail use we'd like to take a look at is grocery stores and convenience stores. So both of these can require a use permit in both districts. But based on our experience with the use permit process and hearings, usually the topics that come up in discussion have to deal with alcohol beverage sales or late night hours operation. And so we'd like to hear your thoughts on allowing these uses by right if we pull the alcohol sales and hours operations out of the equation and require use permits for those aspects. And then we'd also like to hear your thoughts on if there's any, I guess, accessory type uses of alcohol sales that we could consider as by right, such as the sale of just beer and wine and not distilled spirits, or limiting the square footage of the area for alcohol sales. So general personal services, in general, it's kind of mixed on the current regulations on whether where they're allowed by right and require a use permit. I think in general, we think that watch hospitals, coin laundry shops, and barber shops should be allowed by right. There are a few current personal service uses that require a use permit that we'd like to hear your thoughts on. One is being salons actually require a use permit on Webster Street, but not on Park Street. And so we think that it should be consistent across the board. And then upholstery shops currently require a use permit, and like to hear if you guys think that that should be by right. Some other personal service uses that we'd like to hear your thoughts on are massage and tattoo businesses. Currently, massage is allowed by right on the upper floor, but not on, but requires a use permit on the lower floor. And then tattoo businesses are not allowed on the ground floor. And so I'd like to hear your thoughts on allowing these by right, considering that we do have a massage technician permits process that also has background check process for that. And then we also feel like the tattoo regulations might be an outdated perception of tattoo studios when they're considered more of like an artistic type of use nowadays. And then the last personal service use we'd like to take a look at is gyms. Currently, gyms require a use permit on the ground floor, and we think that these uses could be allowed by right. And so I'm going to hear your thoughts on that. Offices is the next topic that we want to take a look at. Currently, North Park Street requires a use permit on the ground floor, and the CC district requires a use permit if it occupies the front 50% of the ground floor on Park or Webster Street and permitted elsewhere. Our thought process here is that a lot of the smaller offices could be allowed by right on the ground floor because usually those types of offices, like dentist offices and that type of thing, have more activity. And then offices over 4,000 square feet, well, we could require a use permit for. And then we'd propose to remove the 50% ground floor requirement. And then the next topic here is medical facilities. North Park Street regulates health clinics. The CC district regulates medical facilities, but we don't really quite have a definition for these. And so our proposal would be to basically require a use permit for inpatient medical facilities and then regulate outpatient services similar to offices based on size. And then we have a commercial recreation as our next topic we'd like to hear your thoughts on. Both require use permits in both the CC and the North Park Street District. We're proposing to update the definition to include more experiential type uses, such as immersive experiences and mystery spaces. And so we're proposing to allow by right instead of requiring a use permit. And so we'd like to hear your thoughts on that. And then billiards is a form of commercial recreation that we'd like to include as a by right with the definition. But there are some outdated regulations that prevent the billiards from being located in the downtown districts and also prohibits minors from attending these facilities. And then during our working group, I guess the reoccurring conversation was about window transparency, visibility into these facilities, and maintaining vibrancy for the active storefront. And so we're proposing a window transparency policy that requires that the first 5 feet into a window be visible and not blocked out. And then we have exceptions for those uses that have some privacy considerations. And then lastly, some of the conversations in our working group talked about increasing the standard business hours to allow for those businesses to operate early in the morning. And so we have a proposal for increasing the standard business hours from 5 a.m. to 10 p.m. And then require a use permit for to open outside of those hours. And then we have an additional option to consider about on Friday and Saturdays allowing businesses to operate until 12 a.m. And so, so the first step that we'd like is to hear from you guys tonight and the community about some of our topics that we have on the list. or any other topics that you guys think we should consider. And then we'll take that back into August when we're writing our draft amendment and then return to you guys in September. And so that concludes our presentation.
Wonderful. Yeah, thank you so much. Great presentation, and I'll bring it to the board for clarifying questions for staff. Yes, board member Sue.
Yep, thanks for the presentation. It was very interesting. One question I had was, for the health clinic, or I think inpatient versus outpatient, and the staff report says there's a definition of health clinic right now. Are we proposing to keep that definition and say that that is going to be basically for outpatient services, and we're going to allow those to be by right within these districts? Or is like health clinic going to still be a separate thing, and we're going to separate out inpatient, outpatient services and say, yes, outpatient services are allowed by right, but outpatient or inpatient is still going to need a use permit?
Yeah, I think our goal is to clarify that how there's health clinics listed in one district and medical facilities in another district. So we wanted to kind of clarify the definition for that, as one as outpatient and one as inpatient, and then require a use permit for inpatient uses. And then we were looking at regulating outpatient similar to just offices in general, which would be based on the sizes. Yeah.
Okay. Yeah, that's helpful, and that makes sense. I think because but I think the follow-up question I was looking at this definition of health clinic, which is a facility, whether public or private, principally engaged in providing services for health maintenance, diagnosis, or treatment of human diseases, pain, or injury. And I wondered if this is like I could see that definition being different from like kind of more of a traditional like medical treatment definition. Like the way the definition is drafted seems a bit kind of like maybe it's like a place where you can go to get like herbal treatments, or I know now modern days people are like doing like peptide injections or something like that. Like, is that what health clinic is supposed? Is that supposed to be different from like inpatient, or how are we thinking? Like, is there an intent to like have health clinic be different from like outpatient, like traditional medical services? I guess.
Yeah, I think what we are imagining is like trying to separate, I guess, your typical dentist office and maybe like a walk-in clinic versus like hospitals. That was kind of like our main goal there. Yeah. And so yeah, it might be revising the definition of health clinics to kind of make that distinction there.
Yeah. And that might still fall under like personal services, maybe. The other question I had, and I was just trying to find this quickly, I didn't look earlier, but how is, I'm sure there's a separate use for like cannabis or like marijuana dispensaries, right? And I just haven't seen them in the definition, but that's totally regulated differently and probably has its own process that is not really, is that going to be addressed, I guess, in this whole process, or is it kind of already got its own comprehensive scheme?
Yeah, we're not proposing any changes to that. It has like a whole section in the ordinance dedicated to it, and then there's also like a section outside of the zoning ordinance that regulates it as well. So yeah, we weren't proposing to.
Got it. Yeah, it's like a very comprehensive state law probably process. Okay, I think the other question I had is, I think in one of the first few board meetings I did, there was a like church that like had to get a use permit, I think, on Park, and I remember that was like, oh, maybe it's something we might revisit later on. Was that discussed in the work group at all in terms of like how to deal with religious facilities, and like how are we maybe proposing to handle them or address them maybe in this update?
Yeah, I guess that wasn't a topic that we covered too much in the working group. I don't recall, but I don't think we were trying to streamline that the process for that particular use. We were going to leave it as a use permit, but we definitely would love to hear your thoughts on that.
yeah, I think I would agree, and I think there was maybe there was something in here about which ones will be changing to use permits, but I agree that should be the continue. I think my comment was along the lines of there's this you're going to be streamlining all these uses onto like general retail, general personal, and I would support religious facility being one of the ones where you call out specifically as requiring use permits. So okay, thanks.
If I may, I think Board Member Hahn was going to jump into. We don't call it religious facilities, and so it's any kind of sort of community assembly. And so we have the Elks Club next door. We do have a number of churches, and then there's other things that we're actually talking about in terms of places where people might have just receptions and parties. It's sort of an assembly use. Whether it's for members or guests or, for the community at large. So those are actually all now in one definition. And I think what Henry is considering is, should those remain use permits in these downtown districts? And I think we recommend yes, because they are a larger gathering with different kinds of dynamics.
Great, thanks.
Yeah, go ahead.
I'm just jumping on.
Yeah,
The assembly uses, thank you for explaining that. It is something that I think should be taken a look at, because I could see small assembly uses, just as you define general retail sales and general personal services, that maybe assembly uses that are relatively smaller in size could be outright permitted, but once they exceed a certain size or occupancy level, perhaps that triggers a use permit. But anyway, that's not a question, so I should be asking a question. So one of the other questions I have, and this comes up sometimes, upholstery shops, they vary from being very retail-oriented to be almost like industrial-oriented. Does the zoning ordinance make a distinction between when a upholstery shop is a retail use versus a more light industrial type of use? Because it seems like as a retail use, that the staff recommendation seems appropriate, but you kind of want to make sure it doesn't transition to a more industrial operation. But anyway, just a question, is there a distinction?
Yes, there's two listings for upholstery. One is small upholstery shops exclusive of refinishing and other furniture repair or manufacturing. And then there's upholstery shop exclusive of refinishing and other furniture repair or manufacturing. So it sounds like it distinguishes that out in terms of manufacturing.
So the manufacturing use is currently not allowed in these commercial districts, right?
Right, yeah.
Okay. Then I have a question. Can you explain why gyms requires a use permit?
It's a good question. I don't know the history to the original reasons why the zoning was zoned that way, but I imagine that maybe it's based on them operating in early hours and possibly maybe where there might have been concerns about them being located where retail normally is located. So if something like a gym's got proposed, what approval is required? So let's see, I think in North Park Street District, if it's located on the ground floor, I think it requires a use permit. And then athletic clubs and health clubs require a use permit in the CC District.
Okay. Well, I agree that's an area that might be looked at to see, because it's a restaurant use from what I can tell. Then I have a question about.
Sorry, I was talking about like health, like gyms, as in like personal training gyms.
Oh,
Yeah,
okay.
yeah.
I thought you said Jim's Coffee Shop.
Oh, yeah.
So,
Oh,
I'm sorry.
You're referring to Jim's Coffee
Okay,
Shop,
all
yes.
right.
Yeah.
All right, my misunderstanding. Sorry. Yeah, I'm getting hungry. Maybe that's it.
They have some good breakfast, so.
Yeah, I like Jim's Coffee Shop. Anyway, all right, thanks for clarifying. But since you mentioned gyms, I did have a question about that. Jim, that's with a G-Y-M. So in the staff report, you come up with some generalized definition of general retail sales and general personal sales, which I think is a good direction. In the following paragraph, you note that 30,000 square foot limitation distinguishes general retail sales. So the question is, with that, are you considering a similar kind of limitation of what triggers a use permit for personal services? Because the only one in that listing that seems like it might be quite large is a gymnasium, the athletic club. So is that maybe something that limit would also, you're thinking staff, that might also apply to, you know, that rare instance of a really large personal service like a health club or a gym?
I think we're interested in hearing if that's something
Oh,
the
okay.
board would be interested in. Right now, we're kind of just using an existing large format retail requirement that's in the CC district.
Mhm.
And so that's where that comes from.
Okay.
But yeah, we could certainly apply that to other uses as
Yeah.
well.
It seems like the general concern when I was reading the committee notes, it was concern about these really large uses, whatever they are, might kind of disrupt the vitality of that retail store. Which kind of gets to my next questions related to window transparency. You know, sometimes these really large uses, they want to close up their windows for, you know, logical reasons. And the proposals is that where there's any window, you need to maintain transparency for at least 5 feet. Is there any current requirement that requires a minimum amount of transparency along the street frontage so that, you know,
We do have, for new buildings in North Park Street and Alameda Point, a very similar policy. It talks about transparency at least 5 feet. And so what we're doing here is proposing to take that policy and apply it to new tenants in existing buildings. Yeah.
No, I get that. I guess my question is, you know, a lot of cities for their ground floor retail in a downtown or active retail district, they want to maintain a minimum lineal feet of transparency windows rather than having, you know, solid wall for, say, 30, 50 feet or so. So does our ordinance have addressed that at all?
Not currently.
Not currently?
Yeah.
Okay. And then my final question is parking. You know, I know that the purpose of this ordinance revision, which I think conceptually makes a lot of sense, is try to remove the complexity and help streamline approval of retail uses along Park and Webster, which makes sense to me. Parking is usually one of the key issues that is causing, you know, a lot of tenants or developers to be able to move in. What are the parking requirements for along this, you know, along both Webster and Park? I remember parking became an issue that we had to do a variance for a use of it. But is that something that's also being looked at, is whether we want to amend the parking, unless we currently have no parking requirements or minimal?
Yeah, currently for Park and Webster Street, we just have maximum parking requirements.
Okay.
And so
No minimums then?
no,
huh?
yeah, no minimum
Okay,
parking
okay.
requirements.
Okay, that's good. Thanks for answering. Okay, thank you.
And just, oh, go ahead,
Sorry.
please.
Henry, don't we have a 30% transparency objective standard? Is that just for residential?
Oh, yeah, you might, yeah.
I think we have something similar to what you were asking, either lineal feet or area of the
Right.
wall.
Okay.
We do have some standards sort of buried in the code of our objective standards, and something
Okay.
like 30% of the wall area.
Okay, good. That's good to
Yeah.
know. Yeah.
And just a friendly reminder to try to speak within 3 inches of the mic, because I imagine it'd be hard for maybe folks online. Great. Board Member Wang, did you have any clarifying questions?
I do, but I think I can save them for the comment period of our item.
Okay, you'll fold it in or layer it in.
They're kind of commenty questions.
Yeah. Okay. All right. And yeah, I don't know. I'm like debating of even asking my question because, but why not? So I was looking at the staff survey of the vacant units, and I don't know. I was just hoping for like a little bit more like narrative on the stalled projects and the unmotivated property owner. Yeah, like not, I understand that this isn't exactly responsive to the discussion at hand, but I think it just could be helpful to know.
Sure. 1 second. So a lot of the reasons why some of the buildings are vacant is because they're old buildings. I think WABA and DABA are 1940s buildings, most of them. So they require a lot of building upgrades, which may not be able to. They require a lot of building upgrades. They also are uses that are not necessarily compatible or very non-dominant at this point. So they require a lot of major infrastructure upgrades just to kind of get them to be even leased. So therefore, it's just it takes a long time, or it requires a lot of capital for that to happen, and then many people are not willing to do that for a small plot of land. For the unmotivated property owners, those are individuals who they own the building, and we've contacted them. We're like, hey, we want to help you lease your space, and they just do not respond. But those are a lot harder to kind of fill. But luckily, there's few of them. but they are the ones that kind of you tend to see, and they are like those properties that have been vacant for 5, 10+ years that really become eyesores.
Yeah, got it. And with those ones that require infrastructure upgrades, is a thought that maybe they could pass on some of those expenses to the tenant, once maybe find one, or it's we have to do that up front before, I don't know. Or does that depend on the negotiations, I guess?
Yeah, I mean, I think it's dependent on how it's structured. A tenant can start renting and then decide that he needs to do all these infrastructure changes. Mm-hmm. But I'm thinking there was one building where they bought a property, they wanted to make it into a restaurant. Because of the occupancy, they required a second entrance, and the building code was not able to hold that, and therefore they just had to abandon the property. So it depends on the property owner can do it to then either make it easier to lease, or then the tenant can establish a business and then figure out what he needs, mm-hmm. and then figure out if he can or cannot do it.
Mm-hmm. Yeah. Okay. Thank you so much. Yeah, I appreciate you entertaining me. So, great. All right, I think that's all our questions then. Should we open it up to public comment?
I don't have any speaker slips, but if there's anybody online that wishes to speak on this item, please go ahead and raise your hand. Not seeing any hands, so.
Okay, great. And with that, we'll close public comment and bring it back to the board. Again, this is a workshop, so we'll continue the discussion that will eventually inform these amendments, but would anyone like to start with any feedback? Yeah, Board Member Wang.
Yeah, generally, I think supportive of staff's recommendations. They all tend to make a lot of sense to me. I just have a couple questions, more in the vein of understanding, I think, the mechanics of how we're proposing to alter and streamline the ordinance. So just to, I think, play back, I think the top line edit that you're proposing is for uses that are permitted by right. You're basically consolidating, collapsing all of that into basically two big categories: retail, general retail, and personal uses. And then the second thing that we're doing is we're taking some of the uses that currently require use permits, and we're kind of upgrading them and saying we're not going to require use permits of you anymore. That fits like a small selection of the uses that currently require use permits, but not all of them. So some of the uses that currently require use permits will still live on that list and still require use permits. For example, community assembly, like we were just talking about earlier, right? Okay, that's helpful for me to just understand, I think, how the lists that were described in our staff report work. But then I think there's I think a category of uses that are currently permitted by right, which don't, I think, get described in the new regime. And the one that stood out to me was hotel. Like a hotel is, I think, not a personal service, right? So, okay, Steve says no. So, so in this new regime that we're thinking about, hotels would not be permitted by right, and they also, they're not going to get downgraded to a conditional use permit. At least not, they haven't been discussed explicitly as something requiring a conditional use permit. So just flat, I guess, just it's a question of what about uses that used to be permitted by right and don't fit retail and personal services?
Yeah, thank you for the question. I guess I should kind of clarify that what we're presenting tonight are kind of just a selection of topics that we were seeking your feedback on, but it doesn't necessarily, I guess, encompass everything that we're planning. I think general retail definition and general personal services definitions are a couple of general definitions that we're working on, but we might also have some other proposals for you guys when we come forward with the amendment in September. But
yeah, I mean, I think what you're capturing is that there are lots of other things that we're just not talking about tonight because either we're not suggesting any changes or we just haven't gotten to that yet.
Yeah.
I'd also point out I think there's a third bucket of things that we're looking at tonight, which is those things that are inconsistent between Park and Webster and North Park, and we're trying to make those internally consistent because they are currently in the same zoning district. So, but historically, those business districts or those property owners, merchants, neighbors had different opinions about things, and so we made little carve-outs, and we're trying to do away with those carve-outs.
Yeah, I mean, generally, I think that the retail and personal services, I think, paradigm works. And my intent in kind of asking these questions is just to say, like, what about this? And so I have a couple of those. So a hotel was one of them as an example. I think something that came up in workshop was, I heard a kind of a general interest in artist studios and artist galleries. So I was flagged that as maybe a question of how that would be thought about or treated as well. And then the last one on my list is offices, which I think you're proposing as by right under 4,000 at 4,000 or under right now. And so I think my comment there is I'm generally supportive of that. I do wonder whether a locational factor and can come into play here. I think that I recall that something that came up in workshop was, hey, our offices may be a little bit better suited off the main corridor on kind of the side streets. And I do think that having offices on, say, a Santa Clara is a little more conducive to maintaining that main drag for retail. So I bring that up as a suggestion to think about. I think I'm going to make a comment that's unrelated to all of this, which also goes back to board member Sue's. I had the same light bulb went off for me because it was also one of my first hearings with the storefront church. And I went back to that one, and I think that when we granted that conditional use permit, we had asked for them to come back within a year for us to review again. And so we don't have to talk about it here. I'm just asking whether that happened, and maybe I wasn't here. It hasn't happened.
I don't know. Well, actually, I don't know.
Okay. Okay.
I don't know for sure, at least.
Something to come back to another time.
Great. Any other, yes, Board Member Hall?
Yeah, I'll just go through real quickly and comment on the list of items staff mentioned. First of all, I think the direction staff is heading towards to try to clean up probably some outdated, obsolete provisions of the zoning code to be consistent with what I see in other cities makes a lot of sense. I think the definitions you came up with is what I see in a lot of cities too. Also, what you just commented on, Steve, about internal consistency between the commercial district makes a lot of sense. I could just see over the years certain things happen and no longer really make sense. So, and that will make it simpler for staff and applicants too, that there's not all these special rules in place for different segments of our commercial areas. So the retail sale of used goods, yeah, I understand that's state law, so that's a good cleanup. Grocery stores and convenience stores, the ABC license issue, I think I would tie that to what are the different categories of ABC licenses that are allowed. There's a little bit more leniency towards this area, certainly beer and wine at a grocery store. Seems that shouldn't trigger a use permit. I don't even know, quite honestly, distilled liquors. I mean, if it's only limited to a small portion of a grocery store, to me, as long as you're not consuming it on site, what's the problem with someone buying a bottle of vodka? I'm just raising it as a question. Not that I've run into that problem myself. Commercial recreation, I do think taking a look at, since it is, placing a use permit limit once it exceeds a certain size makes sense to me. So that's kind of my comment there. Most of the uses are relatively small. How allowing those to be outright permitted uses also makes sense to me. Totally agree with billiards. That's really an outdated kind of definition back when they were considered kind of slimy places, no longer the place. A lot of family-oriented billiard shops these days. And then personal service, all the items you mentioned in the list to allow them to be outright, I think that makes sense to me. Massage parlors are regulated elsewhere by the police department, so I think there's good controls for that. Tattoo parlors are now kind of this, outdated conception. Upholstery shops, you address that as long as there's a clear distinction between what's a retail upholstery shop versus a more light industrial. medical facilities, I think that I don't disagree with the staff suggestion there. The offices, I do totally agree with staff after reading the explanation. It is a confusing section of the code to interpret. And I think using a 4,000, whether 4,000 is the right square footage. Some cities use lineal feet of street frontage as another guide. Not suggesting we need to add that in, but I see that, those two standards, trying to address the same issue. Window transparency is great that we do have some minimum, objective design standards for transparency for new uses. And I would say maybe major remodels, whatever triggers that, should maybe take a look at requiring buildings that maybe are more solid walls, so you need to open up their walls a little bit, regardless of what the use is. And standard business hours, yeah, totally agree that to standardize the ordinance, if that's missing in some of our code sections, then it should be included and be consistent across the board. And the noise standards, I know that's another area that staff is researching, so I won't comment on that. Anyway, so those are my quick comments of the issues that staff has outlined.
Yeah, I think just wanted to echo some of the comments of both Board Member Nguyen and Ham. In general, I think supportive of the overall approach. I think especially with like commercial recreation, how things are just shifting and changing, being able to adapt to new uses or recreation or services that are appearing, I think super helpful. In terms of offices, I'm a bit like on the fence, and I think maybe because this is a workshop, I don't need to comment one way or the other. But I think I'm torn between kind of like some use is better than just a vacant storefront. So like maybe if we allow it by right, then if an office wants to be right on Park, then great, that's better than it being vacant. But then I think on the flip side of it is you're either taking away that space from something that could be more active, or it's going to be occupied by an office that's kind of doesn't have as much of the kind of foot traffic as as another type of more active use. I think the other way I was thinking about this too is demand. Like, is there are there small businesses and kind of organizations saying, we just can't find a place to locate in Alameda. You've got to open up Park Street or Webster so that we can, get more business. I don't think that's happening. So if we wanted to go the other route and say, look, we want to maintain these spaces for more active uses, like we could limit it to what Board Member Wayne was suggesting, is to the side streets. Or I still like the kind of like upper floor use permit, or upper floor is by right use permit on ground floor, but I understand that it's also confusing. So yeah, I'm a bit kind of on the fence on that one, but I do appreciate, I think, staff's approach and thinking, and I also think the kind of change to the window transparency will really help, and I think kind of supports that kind of creativity. I think often to the I think it's called the Audiology Zone, I believe, which is near Signal Coffee. They always have like out front at least like a really nice painting or something that just helps to engage the space, even though it's really just a lobby area. So I think those are all my comments for now, but I think staff has done a great job, and I appreciate the working group thinking through all of this, and I think it is interesting trying to streamline these things like billiard uses, which are, like Remember Ham said, very, very outdated and not the kind of billiard halls we think of in the past. So thanks.
Great. And I guess I'll go next. I'm like the last one to go, so yeah. Yeah, I agree with my fellow board members, and just to be honest on that note with the billiard, I do feel like I'm kind of like old-fashioned or whatever, because like I saw that in the tattoo parlor and I was like, I don't know, but and yeah, times are changing. And I do think there are some safeguards in here to help with that. And I think what I keep going back to, and it's like similar in this vein of argument we're having with the offices, what's sticking with me is like, what does it look like at the street level? So I do, if there is like a tattoo parlor, I appreciate the opportunity to have that window transparency to see like activity, like, and ideally, I don't know, maybe there's like some kind of like little retail storefront in the front, like just some kind of activation. And then I would apply that also with the office use, which I also was like, oh, I'm not sure if that would work, but I do see how it could work if, the front part has like, if it's an architecture office, like really lovely renderings or models or, just like ways to engage the pedestrian. So I think that's the thing I keep going back to, like the window transparency and the activation opportunities if we are going to make these streamlined uses. And then I guess the thing I keep going, I also had the question about the community assembly approval we did a while back and how this was the nexus of this new ordinance with what we approved back then. And the way I think of it is, and I'm not prepared. I didn't like read through the ordinance to like see how it would apply, but it felt like it was like written as a loophole. Like even though it's a conditional use permit, it's like, oh well, we can't really argue against this assembly use. Like it kind of checks the box. And so that's maybe where I go back. I think Board Member Hom, you mentioned, like, is that an opportunity for us to look at the definition of assembly use and like what type of assembly use makes sense for our downtown streets? Because I'll be honest, I am curious for the 1 year anniversary, look back, because I'm not sure if that really was like the best use for our downtown. So, yeah, like how do we want to maybe revisit even conditional use permits in a way that could be interpreted for like the spirit of the ordinance, if that makes sense. So those are two my high level comments or feedback, and yeah, otherwise I think this is great. So any other comments or feedback from board members for staff? No? Seeing no shaking heads. All right. And then was that helpful for
that's great.
you all?
Yeah, thank you very much. Yeah, we have, we also have our consultant, Heather Coleman. She's listening in, and so she's really great at synthesizing comments and moving us forward with the next tasks. So, yeah, we'll be coming back to you.
Okay, great. Yeah. Yeah, I also want to echo my thanks to staff and our subcommittee members for championing this. I know there's, like what we heard, there's a lot of externalities that's happening with downtowns, and I appreciate that we're taking the initiative to address what we can with how we can. So thank you. All right. I guess we'll go ahead and close agenda item 5B. And we'll move on to, so this is a workshop, it'll go to City Council, so go ahead and close the agenda item 5B. Moving on to staff communications.
Yeah.
A couple items. Mm-hmm.
So just wanted to confirm we're canceling the July 27th meeting, and instead we'll be meeting on August 24th, possibly, for a special meeting. We have a local soccer team that wants to establish a outdoor performance space, and so we're working on that, and we have a few steps in the permit process that aren't necessarily just the city, but other agencies that need to comment before we can bring it to you. So we wanted to make sure we did all those things in the right order.
Yeah, I know staff sent an email to everyone. I'm not sure if everyone had a chance to see their inbox about that calendar change, but Yeah, so it sounds like I see nodding heads that that works for us. Great, thank you.
Yep.
All right, and any public comments on staff communications?
Don't see any commenters here.
Okay, great. We'll close that and move on to board communications. Seeing nothing from the board. And any public comments on that?
None?
Great. We'll close that. Any member of the public could speak on something that wasn't on tonight's agenda for 3 minutes. Do we have any speakers?
No speakers.
Great. It is 9:30 p.m. and we are adjourned.